very much for joining us in this module. This is a recording, and therefore you can watch it over and over again. Let me just quickly fix something here. Okay. As I've said, thank you very much for joining this meeting again, or for the first time. I hope you enjoy this module. This is a very, very, very interesting module. And I have started this discussion with my video on, just so that you can see that I am a human being and not artificial intelligence. But I'm going to share a screen with you because I think it is very good for you to see what I'm talking about, and then also to understand and remember, as you can refer back to this. So I'm going to share my screen. So let's just get the screen. There you go. So this module is medical law practice. It is basically introduction. As you know, there's only a few weeks. Therefore, we cannot go into such detail as if you were to do it at a university. But to introduce myself, I am Professor Magda Slabbert. I am a professor at the University of South Africa, where I'm responsible for legal philosophy, legal ethics, and my passion is medical law. My doctorate was also in medical law, and I publish a lot of articles in medical law. Just a side note, you can see my name is Magda Slabbert. My actual full name is Magdalena, so you can hear that I am very Afrikaans, and therefore I apologize for my bad English, but I hope that the content that I give to you, you will enjoy. So I am the designer of this module. I've updated the study material, but I am not the facilitator per se, although I do support Bonnie Venter. Now, who is Bonnie Venter? She is your facilitator for this module. Bonnie Venter was a master student of mine. She shares my passion for medical law. She is much younger than I am. She is technologically far advanced from me. So therefore, she is your facilitator and she will help you through this module. Okay, so I have introduced myself and I have briefly introduced Bonnie Venter, but we do not know who you are. So if you want to, this is not compulsory, but if you go to the forum, you can introduce yourself. You can say a little bit about yourself just for me and Bonnie to see who the audience is. But it is not compulsory and it is up to you whether you want to do it or not. You can also ask questions on the forum, and if Bonnie cannot answer it, she will refer it to me or your fellow um, um, uh, people that's doing the course with you. They can answer the questions, etc. So you're welcome to post any question on the forum, or if you feel like it, you are also welcome to send me an email and ask questions. But that is no problem between me and Bonnie. If we do not know the answer, we will find out and try and get you the answer. So there you see my email address at UNISA. And as I've said, you are welcome to communicate with me should the need arise. But for all administrative matters concerning the course, your registration, the payment, the marks, etc., you have to please call Grace Makuru at LEAD. Okay, then some general matters. You will see that this course is fully online. Therefore, all your study material, all your instructions, all your conversations, etc., will be done online. Therefore, it is extremely important to keep an eye on your schedule. In this video recordings that I'm making, I am not adding specific dates because it must be general and generic. Therefore, you have to look at on your schedule. When are your due dates for the test or for the portfolios or for whatever will be taking place during this module? Bonnie will be once a week online. Then you can post questions. It is not the same as a webinar. For example, she will not be there live and you will not be able to have a conversation with her, but you can post questions and she will then immediately respond. Also keep an eye on the announcements, because in the announcements, if there are new developments in any area of medical law that we feel that you should take note of, it will be posted either under the forum division or under announcements. So keep an eye open. So that is just our way to communicate with you should there arise a very interesting case or an interesting development. Okay, so what is required of you? You will be writing one test, and that will be called test 1, and it will contribute 20% of your final mark for this module. Just a side note before I go into the detail. This module is not difficult, but it is time consuming. So we will expect a lot of reading from you. So as I say, it is not difficult, but you will have to put in an effort and it will take a lot of time. You will do test 1 when you feel you are ready to do it. In other words, watch your schedule. There will be dates indicated between when you can submit your test 1. There's an opening date and an end date. You decide when you are ready for test 1, and then you do test 1 at your own time, but before the cutoff date. Test 1 is based on all the theory, and all the theory is online. In other words, all the theory that you get in the different units, you will have to go through that. You will have to study that, because test 1 is based on all of the theory. For test 1, you do not have to study any extra materials, nor the extra information we give to you under announcements or the portfolio questions. You do not have to study that for test 1. Test 1 is purely based, it's multiple choice, and it is based on the theory given to you in each unit. You do not have to study any extra material. Then you are going to do activities and you will submit it as portfolios, and the portfolios must be submitted in a PDF format, but I will elaborate later. The most important thing of this module is that you need to plan your time. And please, people, listen to me. You will need to plan your time, because the module, as I've said, is not difficult, but it is time consuming. Okay, then be active on the forum. As I've said, if you want to, you are allowed to liaise with the other people in the module. You can ask questions, you can discuss topics if you want to, but at the end of the day, please submit your own work. And then just a general comment, never give up, ask for help. You've paid for the registration, and we would like you to pass this module and get the certificate. We know that the majority of you are attorneys or advocates, and therefore time might be a problem, but never give up. Rather ask us for help, for extension, etc. But then, of course, you need to have a valid reason. Okay, let's focus on the activities that you will be given. Your portfolios will be 80% of the mark. So remember, I said test 1 is 20%. So the other 80% is then for your activities. Therefore, it is the bulk of your percentage at the end, and we therefore ask you to put in effort. That is what we want to see, that you've put in an effort. The questions that you will be asked in the activities is broader than the study guide. In other words, each week an activity will be posted on the website and you will have a week to complete the activity. Then the second activity will come in the following week. So with the third one, once you have done activity 1, 2, and 3, you submit it as one document in PDF format as portfolio 1. What does that mean? You do activity 1 when it is posted, but you do not submit it. Then you do activity 2 the following week, but you do not submit it. Then you do activity 3, you do not submit it. Then you take activity 1, 2, and 3. Make one document of it, a PDF document. Remember to have a title page with your name, please, otherwise we get a little bit confused. And then you submit it on the due date, which will be on the schedule as portfolio 1. Then we carry on. You will get activity 4. You do it, don't submit. You do activity 5. You do it, you don't submit. Then you do activity 6. You don't submit. You combine activities 4, 5, and 6 as portfolio 2 in one document, a PDF document with a title page with your name, and you submit it as portfolio 2. Portfolio 1 and portfolio 2 will at the end of the day be 80% of your final mark. If anything is not clear, then you are welcome to ask if you need help. But I think you can now see the comment that I made, that your time planning is essential. So the suggestion, the ideal situation is that when an activity is posted in a week, to do that activity in that week, so that when the following week comes and you get this second activity, that you have time for that. If you leave the activities 1, 2, and 3 to a few days before you have to submit the portfolio, you will run out of time. Because as I've indicated, we expect a lot of reading from you. Okay, how do we assess the activities? Each activity is assessed in total. In other words, although there is a memorandum where we will indicate the correct answers, there is some discretion that Bonnie may use. Because what we want to see is, did you understand the question? Did you do what was expected of you? In other words, when we ask, give your own opinion, we want your opinion and not the court case, the opinion expressed in there. In each activity, we will focus on a topic that we are doing in this module. So we want to see whether you understood the principles around that topic. And then, of course, we will check and see whether you've put in an effort. And it is very clear when we assess the activities to see whether you have enjoyed it and whether you are proud of it, or whether you just did it the evening before to get it over and done. Remember, you are doing this module out of your own free will. It is not compulsory. You do not have to pass grade 12. It is not matric. It is not a degree. Nothing is dependent on this except that you want to learn something. You want to learn what medical law is all about, the principles applicable, etc. Therefore, it's your own work. It's your own work. Do it to the best of your ability so that at the end you will be able to practice as a medical law lawyer or a legal advisor in the healthcare sector or wherever you plan to go with your qualification. Okay, the study material. The study material which is online is not original work. In other words, I did not write it out of my own head, and I used sources, and I've tried to be updated. But I'm going to discuss the following sources with you that if you want to know more, you can either consult these sources or some of them I recommend you have on your desk should you then practice as a medical law expert or be a legal advisor. Okay, so let's briefly go through the sources and I'll make some comments about them. Carstens and Pearmain Foundational Principles of South African Medical Law. That was published by LexisNexis already in 2007. That book is not available anymore. It's being updated. I do not know when and where it will be published, but maybe in your social media, if you could ask for a second-hand copy, that will be good. It will be an investment. It is a thick book with a lot of information, but as I've said, it is not available in the bookstores anymore. Then there is Dye and McQueen Mason, Bioethics, Human Rights and Health Law, Principles and Practice. That was published by JUTA, an updated version in 2020. Very nice book to have on your desk to go and see certain principles, although they focus on ethics and human rights a little bit more than the peer law. But it's an excellent book. I can recommend it. Then there's another book edited by Moodley, Medical Ethics, Law and Human Rights, a South African Perspective, published by Van Schaik in 2011. I think there is a newer edition, but that is also a good book to have as a reference. And there are a lot of examples in that book. But once again, not purely law, it goes over to human rights and ethics. Then those that are printed in bold. Those are the books that I recommend you keep on your desk. The first one is McQueen Mason and Dada, The A to Z of Medical Law, and it was published by JUTA in 2011. That is like a dictionary. That is a quick reference. In other words, if you come across a question, someone is asking you a question, whether it be on euthanasia, whether it be on stem cell research or transplants, whether it be on blood transfusions, anything in the big spectrum of medical law, you will get a quick reference there and guidance where to look further for more information. Excellent book, excellent investment. The next one, Van der Heever and Lawrenson, Expert Evidence in Clinical Negligence, published by JUTA in 2015. If you are a practicing lawyer, you cannot have a practice without that book. You must have that book because that book have examples in it, and it takes you step by step the whole process, how to ask for medical records, the whole process on which acts do you base your request, etc. Plus, as you will see at the end of this module, no medical law case will be successful in a court of law without expert evidence. And that book explains to you what should be expected of an expert, how to negotiate with an expert, what is expected of the expert in court, etc. It is a book that you must have if you are going to practice in medical law. Then the other one is a loose leaf. In other words, it is updated regularly. It is very expensive but indispensable. And it is written by a senior counsel, John Sainer, Medical Malpractice in South Africa. So it is updated, as I say, yearly. It is loose leaf. It is indispensable. Once again, there are examples in it to help you how to build your medical law practice, etc. So that is, it's expensive, as I've said, but it's an excellent investment. So if you work for a law firm, then ask them to buy that, keep it updated, and you will have a lot of value from it. And then the last one is Potgieter, the quantum of damages in bodily and fatal injury cases, also quite new, 2019, published by Juta. That is now the more detail if you want to see or determine the quantum of damages. And then, of course, do never forget that there are booklets, there are guidance from the Health Professions Council of South Africa, and these you can get online. As we progress through this module, you will see where all of these sources fits in. Okay, what are the outcomes? In other words, the work relevant for your test 1. First, the first unit that we are going to do is the Constitution and its impact on healthcare and access to healthcare services. In our legal system, the Constitution is the supreme law. So we have to see what is the applicability of the Constitution in medical law or a healthcare environment. Then we're going to look at the doctor or hospital-patient relationship, because that is the bottom line of medical negligence law. So we're going in detail on how does this doctor-hospital-patient relationship start, what are the consequences, etc. And then the third bullet is the main part of this whole module. And there we're going to focus on medical negligence. What is the test for medical negligence? How do the courts view medical negligence? How does it impact on civil and criminal litigation, etc.? So the third bullet is the most important part of this whole module. And then after that, we are going to look at the grounds of justification, etc., or the defenses. It depends on whether you work for the plaintiff or for the defendant or for the state, etc. So we're going to look at what could be possible grounds of justification. And then we're going to look at the influence of legislation on the practice of medicine. And then the last unit, those are practical exercises. We will not discuss those in detail, nor will we provide model answers, because these are just examples for you to see what possible medical negligence cases could look like. Okay, so these are the general outcomes that we are envisaging for this module. So there you will see a quote, and it is from a case in the private sector, Mediclinic versus Vermeulen. And it's a Supreme Court of Appeal case, and it was adjudicated in 2015. So I'm going to read it for you because I want to make a few comments. We should be doing a disservice to the community at large if we were to impose liability on hospitals and doctors for everything that happens to go wrong. Doctors would be led to think more of their own safety than the good of their patients. Initiative would be stifled and confidence shaken. A proper sense of proportion requires us to have regard to the conditions in which hospitals and doctors have to work. We must insist on due care for the patient at every point. But this is the important part. We must not condemn as negligence that which is only a misadventure. Right from the beginning, and if this is all that you remember from today's discussion, is that everything that goes wrong in a hospital or with the treatment of a doctor is not per se medical negligence. Things happen. We are human beings. Medicine is not an exact science, and people react differently to treatment. So everything that goes wrong, in other words, if your mother goes to hospital, she is already in her 80s and she dies, it is not necessarily because of negligence. One will have to look at the facts, what happened, and then determine whether it is negligence or not. Whether it be in a hospital, whether it be an individual doctor, if things go wrong, if you have diabetes and you get gangrene in your foot and then your leg is amputated just below the knee, it is not necessarily because of negligence. One has to look at all the facts, and that is what I'm going to teach you in this module. How to look at the facts, how to interpret the facts. But I want you to keep in mind that everything that goes wrong is not necessarily negligence. So keep this in mind. That is the one side. In other words, it might now seem that I'm advocating for doctors and hospitals. No, I know a lot of things go wrong. And if you just Google medical negligence, you will see a lot of terrible, terrible statistics. So if you go to the website of Medical Brief, you will see the amounts there, the amounts that have been claimed because of medical negligence and the number of cases for each province. So it is a devastating situation. We are in a huge problem. There is something terribly wrong in the healthcare environment. Both doctors and hospitals, there's something wrong. And if we had the answers, of course, there won't be any problems. But we have to look at a case by case basis. So in this slide, I just want you to see the numbers and the amounts. Before I carry on, just as a side note, how South African health system works. We have the National Department of Health. We have the Minister of Health, and that minister gets a budget, and that minister is responsible for legislation nationwide. But then we have 9 provinces, and each province has an MEC, the member of the executive committee or the member of the executive council. It depends how they name themselves in each province. So from the national budget, the minister will allocate a budget to each province. And there the premier and the MEC for health, they will then administer that budget for that province. But that budget that every province gets must pay for everything. In other words, the logistics, the equipment, the beds, the bedding, the medicine, the syringes, plus the salaries of all people working for the state in that province, plus the claims should there be a case of medical negligence. So what is starting to happen is that there are so many claims because of alleged medical negligence that the budgets are becoming too small to pay for essentials, to give a good service to patients. So there's a problem. There's a problem, and that problem needs an answer. Once again, there I've added some statistics, and you will see that it is really terrible. So the South African Law Reform Commission are trying to find answers. So are people in the fields, so is the minister, but they haven't come across the answer yet. So when you go to the website of the South African Law Reform Commission and you read the papers there, paper 33, project 141, excellent, excellent document. There you will get nearly all the cases, the past cases on medical negligence. Very good document. It discusses medical negligence. It will be an enhancement to your knowledge if you could read through that paper. Then there's a new one, paper 154, project 141, and that concerns medico-legal claims. In other words, they are trying to find answers for the claims because we cannot carry on as we do. As I've indicated, the budgets are depleted and then patients suffer. So in that paper, they propose different ways of looking at medical law claims. One proposal is to cap claims, other one is to use mediation, etc. But it is not law yet, it is discussion papers, and they asked for inputs, and then they might take it further. As I've said, you can also go to the website of Medical Brief. You can also go to Corruption Watch website, and there you will also see horrifying things that happen in our health sector. That is now the end for today, because this is only an introduction. It's only an introduction so that you can see. I'm just going to click exit and close it and come back myself. Okay, so that was the introduction. I've told you more or less what this module is going to be about. I also explained test 1, the activities that you submit as portfolio 1 and 2. Test 1, 20%. Portfolios 80%, and then that will at the end be your final result for this module. But I hope you are enthusiastic, because I think medical law is the most interesting part of law that you will ever experience. And why do I say that? Is because medical law overlaps, which you will see very clearly with the law of delict, the law of contract, a little bit of labor law, constitutional law, and I'm sure there are many others, but medical law is unique because apart from the law, there are hidden ethical questions, and sometimes there's no specific answer. And sometimes you will feel for the doctor, other times you will feel for the patient. But I hope you are looking forward to this module, and I hope I can teach you something. And as I've said, you're welcome to email me should you have questions. But that is now the end for this introduction, and I'll speak to you again in the next unit. Bye.